doesn't like comfort and luxury at its best? Of course, it's Protea Hotel by Marriott Entebbe. They do have a fully stocked kitchen where they do continental dishes and all kinds of cuisines. They have a swimming pool, a health club, as well as sauna and steam bath. And you can take your friends and family in case you are looking for a place where to enjoy from. And of course, we remember that when we work the whole week, we should take off the weekend and relax. And Protea Hotel by Marriott Entebbe is one of the places that can give you that relaxation. And of course, they are located in the heart of Entebbe town, right next to the airport, and you will find them there. My name is Carol Tumwine Noamani, and you are welcome to Issues at Hand this morning, program where we discuss issues concerning our society, communally, educational, inspirational, spiritual, economics, as well as politics. You're welcome to today's show. Now, recently we were here talking about the Fika Salama Extra launch that police did, and of course it has different stakeholders. We have Ministry of Health, Ministry of Works and Transport, and Uganda National Roads Authority, but most of all Uganda Police Force that is going to implement the core values of Fika Salama Extra. Fika Salama is a Swahili word that simply means get home safe or get where you're going safely, and it is a movement by police to curb errant drivers on the road. And as I was coming this morning, I noticed that they are very, very serious about this because almost after every a few kilometers there is police waiting for you to answer some questions in case you're overspeeding, you're overtaking carelessly, and you are breaking any traffic laws. And my point would be that why would you wait for the police to curb you and inconvenience you? Because this time what they've decided to do is that they're not going to give you a ticket straight away. No, they're going to report you to court, and you will hassle it out with the court. And of course, we do know that that is a very big inconvenience. In case you have where to go this morning, my advice would be that please watch your speed when you are on the road, in case you're a driver or a motorist or motorcyclist. And in case you're a pedestrian, also be very, very careful not to fall in the traps of overspeeding drivers. Welcome to the show today. Today we're going to be discussing some, when we are born, we are born into families, and these families later become part of us, and it is a very, very interesting process how some families later break up because of maybe properties and inheritance that their parents leave behind in case they are to die. And today we want to discuss the succession process and understand it very well as a means to protect property rights and end family conflicts. Now in studio with me are some very, very honorable guests that we are going to be discussing with. One of them is called Mary Nalwoga, and she is a program officer pro bono. And then we have Ronald Kanyesigye, who is a legal officer, Litigation, Uganda Law Society. You're welcome to studio this morning.
Thank you very much.
All right, I'll start with Mary. Could you please explain to us what a succession process is?
A succession. Thank you so much. Mm-hmm. My name is Mary. Mm-hmm. I'm a programs officer. I work for the Uganda Law Society, mm-hmm. and the Uganda Law Society is organizing a pro bono day, okay. And the theme is under ending protecting family property and managing family conflicts regarding property. Mm-hmm. So our theme is under succession, and the process of succession is how to administer, mm-hmm. the process of administering, managing, and bequeathing the rights of the deceased to another person. Okay, that's the process.
Thank you. Yeah. And how do you understand the succession process? What could you add on Mary's submission?
Well, thank you very much, our dear host. Now, my name is Kanyesigye Ronald, and I am a legal officer, Litigation Department of the Uganda Law Society. To add to what Mary has said, mm-hmm. The succession process basically is we are looking at a deceased person has died, mm-hmm. they have left property behind. Mm-hmm. How best can that property be managed? How best can that property exchange hands to another person? Because at the end of the day, the law says that we all have a right to own property. Mm-hmm. So what happens at the time when this person dies? So Those are the processes of succession we are talking about. Who's going to hand over this property and who's going to manage this property? Does this person have a wife? Does this person have children? So how best can we hand over this property to these people that are supposed to be having it? Yes, basically that's what I can add on to what she has to say.
All right, and how does the succession process contribute to protecting property rights within families to Ronald?
Thank you very much. The succession process in the first place it's very important because at the end of the day we are all going to die. That's a fact, for a fact. But at the time we die, we have something we leave behind. We have children. So if we do not have a proper succession process, those are the fights you hear, that somebody has killed a brother, has killed a sister, has killed a mother, because he thinks the father has left him something, yet not, or whether he has left him something, either he's been denied something. So you find the succession process is key and central to make sure that we are having a peaceful community, a peaceful nation. Because at the end of the day, family is the first unit in as far as nation building is concerned. Yes. So if we have a peaceful family, we have a peaceful nation.
Okay.
Yes.
Thank you so much. Mary, can you explain the key steps involved in a successful succession plan to ensure a smooth property transfer?
Thank you so much. Managing and distributing property of the deceased, it's a process, but it also depends on the facts of the deceased, what he left, and also the law also provides for that process. But first thing first, we are here also to tell the public about that process. Like when a person dies, what do you do? What happens? And then even before you die, what do you do? Because most of the people, they leave property and they don't know what to do, and that brings family conflicts. So the first thing is that we sensitize the public to write a will. That is the first thing a person starts with. You write a will, and then you bequeath your property, or you give out your property as you want it to be distributed to your children, to your wife, or to your husband. And then after that, when you die, in the will you leave what we call an executor. The executor is the person that you put in who is entitled to share that property. So not to distribute or to manage, but not to sell. Because some people, when you put an executor, most of them feel like, it's my right, I need to sell. The person left a wife or left a husband or left children or young children, and they sell it off. No, that is not the work of the executor. So after you being put in the will, you go and apply for letters of probate. But then you have to think of the administrator General's office. That's where you apply for letters of no objection. So they give you a letter, like it's letter of no objection, like there is no person who is disputing regarding your rights as an executor. And thereafter you apply to court and get letters of probate. That's if a person has left a will. And if a person has not left a will, there you've left circumstances open. So that's when we encourage everybody or to the public, like, this is what you're supposed to do. As a family, you need to sit down and choose your administrator. Now, the other one is an executor. This one is an administrator. So you choose your administrator, you make minutes of the family, you sign on them, and these are the minutes that go to the administrator general's office. And you apply for letters of administration to court. But you have to go to the administrator general's office first. You have to go to the office of the cow, and you report all these cases, and then you go and also acquire a death certificate of the deceased. Some people do not get that, they just run. So you need a death certificate, and then after that you go to the administrator general, you get a certificate of no objection that this is the person we have chosen. An administrator, still, you don't have the right to sell the property. You just have the right to distribute the property, and it has also its timeline under which you're supposed to have those letters. Now they have given us new guidelines recently. You're supposed to possess within 2 years. You must have distributed the property and given a report back to court that this is what I did. I gave this to the wife. I gave this to the children, and that is your work.
Okay.
So you apply to court and also get letters of administration. Basically, in brief, that is the process.
Thank you. We will be talking about the Pro Bono Day later on, but I'd just like to continue with Mary and understand what are some of the common challenges of conflicts that arise within families during the succession process.
The common challenges of conflicts, of course, are many. And that's why we hear so many. One, the common challenges is that if a person dies intestate, like there's a testate and an intestate person. When you die without making a will, your conflicts are going to arise. One, you've left the property to the family and they don't know how to deal with it. Two, you've left children, sometimes they are not known to the family or they are known by some family members. Three, you've left property which is maybe far, or you have copyrights, or you have things that are not known. So when you live without making a will, family conflicts arise. That's when we see people fighting for property and then children are left out. So those are some of the challenges. Secondly, when someone leaves a will and leaves an executor, the executor feels like I have full rights over the property. So they sell off the property, they manage the property, they distribute it to themselves, leaving out the beneficiaries. So those are some of the conflicts, and you find the beneficiaries, these are people who are entitled also to part of the estate. They also come up and start fighting for the property. I think those are some of the few: selling of the property, being entitled without considering other beneficiaries, and then also we have fraud. Some people forge letters of administration. They say, okay, I am the administrator, but literally you don't have those rights. You are not the administrator in the first place, or you are not the son of the deceased, or the wife. So they forge so that they get that property. So we've received a lot of those complaints.
Thank you. Ronald, would you like to add something on the challenges or conflicts that arise?
Yes, of course. There are very many challenges that arise. You see this property. Usually, it comes with the fact that it is an African setting. It's really patriarchal in nature.
Okay.
So sometimes you find a boy is born in a family, and he grows up knowing that I'm the one who's supposed to take over my father's property.
Exactly.
So you start getting issues of fighting, and then we are having issues whereby the family sits, they agree that this property is family property. This is where we are going to bury our people. You get it? But then the son of the home usually comes and says, and you find him selling off the same very property. So you find people coming to us, they are crying. We left this portion of the property. We divided the property. We took all our shares, but we left this one. Now this boy has come up. He has sold this property. We now don't have where to bury our people. So those are some of the challenges that come. And another biggest challenge that I've also realized is ignorance of this law. And it keeps on changing now. These days, it keeps on changing, just to make sure that that the whole process is streamlined. Yes, it keeps on changing. And whenever these people in the villages sit, they don't care to say that let's consult a legal practitioner, or they think legal practitioners are even more expensive or something like that. But there's legal aid going on, and usually in legal aid and pro bono services, they usually provide advice. It's you find people running to LC1 chairman. They have no idea on how these things go. So usually you find people in the villages, they lack that sensitization. Okay. That sensitization is a space that is still lacking, and that is causing most of these issues. But something can be done if the community takes the initiative. Even chairman can usually approach our legal aid centers, and we usually go there and we do sensitizations of the same. So it's important that you invest in the knowledge of succession, because at the end of the day, this is something that is going to determine your afterlife. It is something that is going to protect your afterlife. So don't be afraid to make a will, because people, when you say you're going to make a will, somebody thinks is going to die.
Exactly.
Yes, and usually it's not the case. It's not the case, really. It's not the case. You see, when you say you're going to make a will, it does not mean you're going to die tomorrow. No, it's you saying, I'm just putting my things in order.
Okay.
Yes.
Thank you. All right, so how can a well-designed succession plan help prevent family disputes? You've been explaining it, but could you go a bit deeper with it?
Okay.
Yeah, so how can a well-designed succession plan help prevent family disputes and conflicts over property rights?
Thank you very much. You see, a well-designed succession plan, it will help you in a sense that it envisages that in future we are going to have a conflict. You get it? So if we are going to have a conflict in future, how best can we resolve it before it even happens?
Okay.
You see, because before a person dies, you may not see what is going to happen. When a person really dies, that's when you see the drama.
Yes.
The drama unfolds before your eyes. And then before you know it, this one is killing the other one. This one is witch hunting the other one. You hear cases of witchcraft. You're like, what's happening here? So, a well-designed succession plan is there to resolve such a thing.
Okay.
Such a thing of property. People kill themselves over property. Land has become a problem. Land has become a problem in this nation. And it all stems from the fact that people don't really know the things. And they don't care to even ask. Some are just greedy. They just want to take over their father's property. So a well-designed succession plan can help resolve conflicts of family, can help build up a nice and a very well managed family. It can help in making sure that even where you're supposed to be buried can actually even be put in your will. Okay. For example, we've had cases whereby people are fighting for the body. You get it? Recently, we had a decision in court of the late justice. Yes. Whereby the husband of the late justice was saying, we are going to bury this person in my home, but the children were saying, mommy said that we are going to bury her in her ancestral home. So we had that issue. Can you imagine? We had that issue. We had to go to court. They had to argue and argue over somebody who has actually died. You see, a well-designed succession plan is there to resolve such conflicts even before they happen. So, invest time. I encourage you viewers, invest time in understanding the succession laws. Invest time in getting practitioners, legal practitioners. They advise you. Making a will does not mean you're going to die. Making a will is you saying, let me just put my items in order. Yes, thank you very much.
All right. Mary, are there any legal requirements or frameworks that need to be considered during a succession process to protect property rights?
Yes.
Okay, tell us about them.
Thank you so much for that question. There are legal requirements. One, when a person dies, you have to process the death certificate first. It is a requirement that the family members have to make sure that the death certificate is in place. Secondly, those who are like the beneficiaries of that estate, they should possess valid national identification cards, because these are things that they are going to keep asking. Where is the death certificate? Where are your national IDs? Can we have copies? Can we have, even right now, can we have pictures, so we know that this person passed on. Okay. But remember, it also starts from the grassroots, where the person died from. Do you have a letter of the chairman where that person used to stay? So it's a requirement that you should start with that, so that the chairman knows that this reports in the letter that this person died on such and such a day, used to be a resident of this place, blah, blah, blah. So you start with the letter, and then you process death certificate from NIRA. Some people stop at this certificate which they get from the hospital, but you need to get the death certificate from NERA. And thereafter, you use these, maybe if the person died tested, you use these requirements while applying for letters of probate. And letters of administration, still you have to sit down. The legal requirements are you have also to have minutes.
Okay.
You must have sat down as a family. 1, signed on those minutes. 2, those minutes are witnessed by people who are available. 3, those minutes have dates. Sometimes, it can become a problem because people, 1, they formulate their own minutes and they put their own dates. 2, people forge signatures. So we have to put all that into account while applying for letters of administration. And then a person who is writing a will, also a will has its legal requirements. You do not just sit down in your house and you write your own will. And then you say, okay, when I die, I bequeath my property or I give out my property to this person. No. The will also has legal requirements. 1, it should be dated. Because people formulate their own wills. Someone can sit down and write their will. And they write another person's will, by the way. Not say, okay, I'm writing this person. But remember, you're not the person who died. I don't know if you're getting my point.
I'm getting it.
Yeah. And then this person is writing a will of a dead person and is putting himself as the heir or as the executor of the property. And people are wondering, where did you come from? This uncle, where is this uncle coming from? Then he says, I am the uncle of the what? That's why I've seen cases saying, let's exhume the body to do the DNA whether this person is related to us. Okay. So if you're doing a will, it has to be dated, it has to be witnessed, more than 1 witness, that these people were available. And then it also has criteria. There are wills which are even disputed because you can say, my property shall go to the family of maybe Kamoja. But then people are wondering, okay, which family is in Kamoja? How many people are in Kamoja? Do you have children in Kamoja? So you have to state everything. Like, I have 4 children. I have property here. I have by the banks are also taking money for people who have died.
Of course.
The moment you die, you've not told anybody that you have an account. You have 100 million on your account. Your wife does not know because you fear she will come for the money.
Of course.
Your children are not aware because they are young, or you don't want them also to gain the money. But please have somebody to know that you have an account or you have an insurance policy whereby, in this insurance policy, I have my 30 million. So these are things you put. I have a policy with Old Mutual. I have a bank account. I have 300. So you bring out everything. Okay. Even some people hide children. You've seen also issues of DNA coming up here and there. So this is your opportunity also to say that this child belongs to this person, or this child has to benefit from my property, because we've seen children who have stopped going to school and their parents were rich, because of such circumstances that were not provided for. So you have to write down everything that you feel and any person that you feel should benefit. And some of these people are also like these are outside beneficiaries. They don't have to be really children, because I've seen a case whereby the child was not the real child, like a grandchild. And some of those people are fully dependent on the the deceased. And then someone comes and says, this one is just a grandchild, let her be left out. Second, we have seen maybe the deceased left a daughter, and that daughter had children, but that daughter also passed on. So those children are also left out, but they should benefit from their mother who passed on, because their mother was also a son or a daughter of the deceased, to the deceased, yes. So we have to put everything in order. When you're writing a will, it has to be dated, witnessed, and signed. Because if you don't sign, that will is invalid. If it's not dated, it is invalid. If it's not witnessed, it is invalid. We shall still go back and other people will distribute your property.
But how would you know a forged will, and what legal action is taken when the will is forged?
Of course, when the will is forged, you go to court, and then we have experts. You involve in experts. Now we have handwriting experts. We compare some documents where I used to write. The handwriting person can come and say, let's compare whether this person is really the person who signed here. So we compare the signatures, and then we see that, oh, this person was not the person who signed here. Secondly, we have issues of maybe family members also knowing and say, okay, for me, you are putting yourself, but somebody told me, the deceased told me that you are not what? The heir. So if you have, it depends on the law, but also facts come in. Because you cannot put yourself as the heir or as an executor when the family has rejected you. The family will say, no, we want this brother because we feel he's the right person. And you give your views as to why he is the right person. So if at all the will is invalid, you can apply to court, you get an expert to check it out, to see the handwriting, to see the signatures, and if they are wrong, then it shall be put aside.
All right.
And then we go back to the other procedure whereby a person dies intestate. Now you left no will actually at that time.
Okay. Ronald, how can somebody keep their will safely, and what are some of the procedures of keeping a will safely? Because we believe there are some people who have an evil eye. When they see it, they might do alterations and stuff.
True. Thank you very much for that. It's important to know about the safety of your will. First and foremost, the safety begins with the fact that the information you're giving is actually really safe, or in other words, no one gets to know it's your secret. That is safety, the safety pin number one that you have to put there. So whenever you're making your will, get someone you can truly trust. Get someone you can truly trust. What do I mean? Speak to a lawyer. A lawyer can help you draft a will. Can help you draft a will. Or speak to maybe if you're a church person, you can have a reverend or your pastor whom you know that is in a position of trust. You get it? So once you're drafting your will, draft it carefully. Let the person who's helping you, a legal practitioner, a lawyer, help you and guide you on the necessities that are needed. You get it? And all that has to be secret. For us lawyers, we are trained to, a person came to my office and made a will and he gave this and this and this. No, the first safety pin is the information. Yes. So now, once this has been fully drafted and completed, where else do you take it? Who will keep it? You can keep it with your lawyer, because for us we usually have our cabins, where we keep information of clients confidential. You even forget the cabin exists. You put it there, you file, and when need arises, that's when you open.
Okay.
Yes. Then you can keep it with the bank. Banks have safety boxes where you can put your will.
Okay.
Yes. You can keep it with your church, if you know that you can trust the people of your church. But mostly, usually people keep their wills in banks.
Okay.
Yes, they keep their wills in banks, and when time comes, the lawyer usually goes to the bank, and then they get the will, and then they read out the last wishes of what? Of the deceased.
Okay.
So it's important that you understand that once you're making a will, it is totally a secret. It is confidential. Okay. You don't want to cause problems or people to kill you early. That someone can kill you early because they have seen your will and they can't wait to take on them.
Of course.
Yeah. So it's very important that you keep it a secret. Understand that you need to have this will validated. Make sure that it is very well witnessed. And by the way, let me tell you one thing or two. You can still amend. Let's say, like, maybe you're not yet married, and you make your will. You have your properties. You make your will, and then maybe in the picture you get married, and then you have children, but you already have a will. So what you can still amend.
Okay.
Go and make a new one, and whenever you make a will, make sure still it is witnessed, it is signed. You have to sign on all pages. with your signature. Your signature, make sure that the signatures that are on the IDs, your signatures that appear on your documents are the same signatures that appear on the will. You don't want in future somebody to start questioning your will.
Yeah.
Simply because they are not satisfied with the property they have received. You see, yeah. So you don't want those issues, and then before you know it, your last wishes are not what? Respected. So you have to make sure that everything is done. Safety begins from the time you're writing the first letter to the last one, to the last dot. Before you even think of a bank, before you even think of someone who can keep it for you, you have to put safety in terms of no one needs to know. It's your little secret. That's a will. That's why I encourage people, make them. Make them, because they're secrets. They're just secrets. They're not going to go in the public. Simani, this one has made the will, so he's about to die. Let us witch hunt him a little bit. Yeah, there are some people who are like that. So so you have to be careful from the word go. From the word, if you say, okay, I've decided to make my will, be extremely careful. Make sure that the people who get, even the witnesses who sign on the will, they are not supposed to know the contents of your will. They are not supposed to know. All they need to know, all they need to see is the fact that you signed on this will. That's all they need to see. But they do not need to see the contents of your will. That's all safety. Because you don't know, the witness may go ahead and start talking.
This one was not given.
This one was not given. This one was given. No. That's not acceptable. Make sure that even the witnesses you bring, they are not allowed to see the contents of the will.
Okay.
They are not allowed. So all they need to do is, we have seen him sign on the will. And when they are brought to court in future, let's say you envisage a future court action, all they are going to do is, all they are going to confess before court is that we witnessed him sign this document.
Okay.
Yes.
Thank you. We're still discussing the succession processes and succession law in general, and we are at the part where one must make a will in case they pass on, and the family is supposed to receive it and know exactly how to handle the properties and estates. But we're going to take a very short break and return with more. Don't go away. It's Issues at Hand, and we are powered by Protea Hotel by Marriott Entebbe. We are still here discussing succession, but it is a very tricky topic, because you can imagine losing your father maybe, and then your elder brother decides that he is the heir to the property and everything, and he decides to share it according to how he sees fit, instead of according to a will that was written by the deceased. And my question to my guests today would be, how is an heir supposed to behave? Is it right that an heir is supposed to take the biggest share of the property left behind? And maybe I'll start with Mary, then go to Ronald later.
Okay, thank you so much. In my view, most of the times in our communities, basically we live in a patriarchal society whereby they believe that the boy is supposed to inherit the property. That's the first thing. Secondly, he's supposed to be the heir. So whether there is a wife or there is anybody, the boy is supposed to be the heir, which is not provided under the law. It's nowhere provided that the boy should be the heir. But however, because we live in a patriarchal society, culturally that has affected distribution of property in the family. So most times when somebody writes a will, be conscious and also put the purpose of the heir. And that is if you've approached a legal person to guide you on that. The purpose of the heir is not to distribute property, is not to manage property, is not to sell property, is not to administer property, is not to bequeath the rights of the property to another person. That is not the work of the heir.
Okay.
The work of the heir is basically to stand in the shoes, maybe if I use a simpler language, to stand in the shoes of the deceased.
Okay.
That this has taken on like the bloodline of this person who has passed on. So he can just maybe say he can act as the father of that property, of the people around. He can guide, he can continue with some of the wishes of the deceased person. Like maybe the deceased person wanted this and this, and he say, okay, we can continue with these wishes. We can continue to keep these children. We can continue to look after the children, just like how the deceased wanted. But if you distribute, that is not your work. However, we have an executor if there is a will, and we have a person who is the owner, letters of an administrator. Those are the two people who are supposed to distribute property.
Okay.
So the executor, that is their work, to distribute, to manage the property. And then the administrator, that is their work, to manage the property. However, you also have a time limit. When you're named an executor, some of them take long to be, and they be with the property, they own it, they say this is my thing. No, that is not your thing. Your work is to distribute property to the deceased, and you give a report back to the court that this is what I did.
Okay.
So basically that's how you're supposed to, but this is to tell the public that the heir has does not distribute property. And secondly is that it's not supposed to be a boy. You know, recently we lost, a person, was it in Sibambi? Not in Sibambi. There's a person who passed on and only had girls. So one of the girls was the heir, and the public came up and said, why didn't he have a boy? Why didn't he have a boy? But hey, women can also right now manage property.
Yeah.
So it's not about boys. Even the girls, after it has been proved that they are keeping the property of the deceased even more than the boys.
Of course.
The boys get married, they get problems, they start selling off the property. But girls, I think, are managing the property of the deceased better. If we at all we do a survey on that. The boys, they go very fast because they have to look after their wives, their children. But for me, I can be comfortable. I have my husband, we are managing our lives, but at the same time, I have interests for my dad.
Yeah.
I want his property, I want his legacy, but the boys are quick at selling.
I know.
And then also the last that I can say is that please, if a person left a spouse, that is the first person to consider to be an executor or to be an administrator. You know, because he has the best interest most of the times.
Of course.
But we need to also talk about the extended families. If you have an extended family, like the person has left, another family, that person should not feel that, because left a legal wife, so the other people should be left out. No, that's when you bring the wife and also another person so that they administer. So we can have more than 3 administrators.
Oh.
So you can put like 3 so that they everyone's interest has been included in the wishes of the deceased.
Thank you.
Yes.
Ronald, are you adding something on how an heir is supposed to behave?
Yeah, now, I think what is key is really understanding the difference between this legal heir and an administrator or an executor. You see, a legal heir, as she has explained, maybe just to expound more, is this person who's going to just inherit, should I say, the bloodline, keeping it up. You get it? Wishes of the deceased, you have to keep them up, keep them moving. You know, he has been trying to build a school. How best can we keep on, the project? But an administrator is a person who has actually been appointed by court to distribute the properties of what? Of the deceased.
Okay.
Is not an owner of the property. No, he's there just mainly to distribute. A legal heir, you're there also as part of the beneficiaries. You're part of the beneficiaries. You are not really a person who's going to distribute this property. No, you're part of the beneficiaries. You're part of the journey of keeping up the property of this person, of the deceased person. Okay. Yes, and an executor is a person who has been named in a will to also do the same, distribute property. As well, you have to get that authority from the courts of law, because you have to apply for the grant of property in the courts of law. So that whole business of saying that is an asikila tatawa, neda you asikila bloodline, you get. You just carrying the bloodline of your father, but it does not give you the authority to go and step on a widow for instance, and you start selling off the property, because the law now is clear. In case there is no will, let's say a person has died intestate, the widow is usually the first priority, because these properties were gotten with the husband. She got these properties with the husband. You don't know what they really went through even before you were born. You get? They know the story. That's why she's the best person. And in case she's not able, the children who are going to apply for these letters of administration, they need her express consent.
Okay.
Yes, she has to give them consent and tell them, you know what, I'm not able for this and this and this reason. You should go to what? You should go and apply. That consent can be written, or she can even come before the courts of law and tell the registrar or the judicial officer that I've given my consent to these children to apply for letters of what? Of administration for the estate.
Okay.
Yes. So basically, that's what I can add on.
All right. Thank you. Are there any cultural or societal factors that impact the succession process and family conflicts over property rights?
Definitely. That's this is Africa. Yeah, and it's still the same story, whereby we are living a patriarchal society, whereby we appreciate whenever a boy child is born. Whenever a boy child is born, the first thing they say, I've gotten a musika. A musika of the home. You get? So usually, but it is said in a sense that this boy is going to inherit the property. But then you forget, there are other children. There are girls. Probably it could be the same boy. One boy like this, and there are only girls all over. So you find, in the circumstances, you find there are those issues. Some uncles, they are saying that girls are not supposed to be inheriting this kind of property. These girls get married and they leave, so there's no way how they are going to maintain their property. They will just give that property to their husbands. Okay. So usually there are those issues, but then the law is saying that we are all equal under the law. Okay. There's no way how you're going to say that a boy is more favored than a girl, save for the time when if those wishes are expressed in what? In a will, because if it is my property, I can distribute it the way I like. If I decide to give you a small piece of land, that's my wish, because that property is not yours. People understand. If your father or your mother makes a will and even give you a small portion, don't take it in bad faith. It is their property, not yours. That one I would like to emphasize. You're
even lucky that you're getting.
You're even lucky, because why are you waiting for your mother to die
exactly
to get a property? No, it's morally not right. It's just wrong. You're just seated in your father's house, your mother's house, waiting for them, or grandmother or whatsoever, waiting for them to die, so that you can take on and you start creating chaos. No, let me tell you, it is not your property. It is their property. Please desist from, if they give even a small 40 by 40, just take it and appreciate God that this person has thought about me, or else we shall remain in this whole conflict zone, thinking that my father does not love me or my mother does not love me. Your love for your father cannot love you based on the property he has. By the time he gave birth to you, he loved you enough. Exactly. So those are some of the issues that we keep getting in Africa with these things. Yes, and maybe what has also changed culturally is the fact that now we have properties which are not now land. Copyrights. You're a musician, you have your songs. You get it? Copyrights. Please, those are also properties. It's what we call intellectual property. Yes, we have copyrights. We have patents. You get it? So we have people who have written books and they are still getting loyalties out of them. We have franchises. Somebody gets a franchise and puts it up and they are still getting some loyalties. All that is property. All that is property. And you know, it's important that we shift from this whole perspective of just land even if it is land. Of course, land is an issue, but there are also properties that need to be given attention, even when you're writing your wills and what. Musicians, I'm talking about musicians and creators of art. Those are properties.
Okay.
Yes.
Thank you so much.
You're welcome.
I'd like to end with Mary telling us about, of course you have your last words, but Mary should tell us about the day that is coming up, the Pro Bono Day. Tell us about it.
Okay, thank you so much. The Uganda Law Society is a membership for all lawyers in Uganda.
Okay.
Like if we all practicing advocates have to register under the Uganda Law Society. So the Uganda Law Society also has the legal aid project. Legal aid and pro bono services. This is a way of giving back to the society through providing legal services to the community freely. By the way, you don't have to pay. In case you need consultation, you need to know about pro bono. Pro bono means that the lawyer gives a service without any payment. So that's why we are here today. So we usually have an annual pro bono day where we celebrate and we invite the public at the railway grounds on the 1st of September to come and we celebrate this day together. In how long? Like this is the 14th pro bono day actually. We've been celebrating it for 14 years. And that day we invite all lawyers in Uganda. Now in Kampala, we shall have it at the railway grounds on 1st of September. It's a full week, but we round it up on 1st, and we shall have the guest of honors, Honorable Norbert Mao, and we have different guests invited. However, also the public, we invite everybody who has a question, any legal issue regarding succession, please be available, because we shall have a desk for the Administrator General just on that day to give back to the community by giving free legal advice. That if you have property, if you want to write a will, if you want to know about the procedures of managing and distributing the property of the deceased, please come and join us on 1st of September at the railway grounds, where we shall advise you, we shall give you and if you have a case that is also continuing, please come and register with us, because we have the pro bono service. You come to our offices the next day after 1st, and then we shall register it as a case and continue with you. So on 1st of September, we shall have different people, and the lawyers that day, by the way, around the country will be available. And it's celebrated, by the way, countrywide. In Gulu, we shall have a pro bono day. So people in Gulu shall also convene, and they will celebrate together. Then in Soroti, we also have a day. We're still 1st September. So you don't have to be in Gulu to come to Kampala to meet a lawyer. We also have lawyers in Gulu. So we have also lawyers in Soroti. So meet there, and they shall guide you. We have also our offices there. And then in Soroti, Amina and in Mbarara, we have. In Kabali, we have. In Kabarole, we have. So we shall have all these centers. In Masindi, we have. So we shall all have all these centers celebrating 1st of September, meeting the public and discussing legal issues, legal advice, and also taking on cases without any pay.
Thank you so much. Because of time, let's end here. I would like to thank my guests so much for a very beautiful discussion. And in case you have any legal matter that you have to maybe find out about, 1st September is your day. It is the Pro Bono Day, where lawyers will be giving free legal advice in case you go to one of their grounds. It is around Uganda, the whole country, like she has said, and you don't have to come to Kampala in order to get these services. My name is Carol Norman Tumwine. Thank you so much for being a part of Issues at Hand. We'll see you tomorrow. Bye-bye.